What's important is you have to realize what is the long-term goal for the client and for you in that case, and then try to achieve that in the best way possible. In that process, you may lose some small battles, but the idea is to win the war, not every single individual battle.
A very warm welcome to everyone. We are here again, Super Lawyers team, with yet another enriching and informative session with our new guest for the day. So let us welcome our guest for today's session, Mr. Avinash Amarnath Ji. Thank you so much for accepting the invitation. For all our viewers, just a brief background of Avinash sir. He is currently the partner of Competition and Disputes team at Chandhiok and Mahajan Advocates and Solicitors, leading the firm's Hyderabad office and South India disputes practice, specializing in advising clients on complex competition law and dispute matters. Sir, a very, very warm welcome from the entire team here at Super Lawyers. We are eagerly excited to have your insights on board.
Thank you. Thank you. My pleasure to be here.
Sir, after a decade of commendable excellence in legal profession, would you mind elaborating why did you choose law? Was it like a calling to you, or was it a very conscious choice at the beginning?
So for me, my father is a practicing lawyer and my mother is a law graduate, although she didn't practice. So law was always in the family, but it was never thrust upon me. I was given the freedom to choose. So I think I would call it a conscious choice. And to be very honest, at the time of choosing law, I chose it almost by the process of elimination. I didn't want to do science. So I had an option between commerce and law seemed very interesting because I had an interest in humanities as well while I was in school. So I thought that that would be better served when I studied law, so I could study political science. So that was really the reason for choosing law.
That was precise and to the point. Moving on with the next question. Sir, you have been robustly working with the corporate culture for years now. So, what keeps you going in this particular corporate environment? Any particular routine or any particular professional discipline that you want to share with us, sir?
So, I mean, I think the first thing I would say is that the routine that works for me may not work for others. So, I think the first general advice, if I may, is that everybody has to find their own routine. But in general, I think a few tips that I've noticed is sleep early, wake up early, and avoiding screen time. You realize actually you have a lot more time in the day than you feel that you have, especially if you follow these few things. And then I think it's very, very important, especially as you said, in this stressful corporate culture, you have to prioritize your family and yourself. So one of the things that I was told as a young lawyer by somebody who used to run a law firm, and something that stuck with me for a long time and which I try to follow, is that he said, look, how much ever work you have, whatever deadlines you have, always dedicate 3 to 4 hours to the following things. One is to your family, second is to physical exercise, and third is any personal hobby that you have, and try and guard that time scrupulously and strictly. So that's sort of what I try to follow to maintain that discipline. Of course, I think the most important thing in this, I would say, is that unfortunately, the corporate culture demands that you have to be flexible. So while this is a routine, this routine often gets broken, but you have to be innovative. For example, I have to travel a lot. And when I travel, obviously, some of this strict routine gets broken, but then you have to be innovative and try and find alternatives. So if I've been traveling too much, then I make sure that that weekend I completely reserve for my family. And then even when I'm traveling, I try to do like quick 10-15 minute exercises in the mornings. So that's, I think, what I've realized. And obviously, this is not something I just picked up immediately. It's taken me 10 years to figure out this routine. So it'll take time. And I think, as I said right at the beginning, this works for me, it may not work for somebody else. So the idea is to find your own routine and what makes you tick.
Thank you, sir. I am sure we all will understand the importance of limiting our screen time. That is the talk of the day. And along with that, the way you have said that we have to balance all these things, we have to balance family with howsoever much we are under this pressure. This is also very crucial wisdom, especially for the ones like me who are just starting out. We'd move on with our next question. Being involved in dispute resolution definitely has a lot of strategizing and planning. So how did you develop your flair in dispute resolution sector? And how much do you enjoy it as well? If you could elaborate, sir.
Absolutely. I think I was lucky to have very good mentors and guides when I started off in my profession. But the most important thing in litigation, especially strategizing and planning, is paying attention to detail. So, one of the first things that I was told very, very early is you have to read the entire file, whatever it is. It might be a small transfer petition matter. Even let's say the matter is getting adjourned, I was still told you have to read the file as much as possible, front to back. So I think that sort of being ingrained in me from the beginning then made me realize that sometimes the more you read and then reread, new things come to light which you wouldn't have thought of before. And that really helps you plan and strategize. Because what happens is the first time a client approaches you, he gives you a very broad perspective, and sometimes they're giving you their perspective, which may not be reflected in the documents. So purely limiting yourself to that is not sufficient. So you would have to test what the client is saying by looking at the documents. And then, as I said, the devil is in the detail. So I think that slowly brought that flare up for me that the more I read, the more I feel that, I'm very confident with a case and the more I can strategize. And also, it's a process of evolution, right? As a young lawyer, I think your role is limited to knowing the facts well. If you have a strategy, great. But usually, as a young lawyer, you're not expected to have the strategy, but you're expected to have the backup, knowing the facts properly, having the research on legal points, etc. But as you grow older in the profession, then you get to start doing the actual strategizing. So now, it's like a game of chess. You make a move and you see how it works out. Sometimes it works out, sometimes it doesn't. So when it doesn't, you have to go back, regroup, try a new move. So it's like a constant game of chess. And I enjoy that. And I think also with strategizing and planning, especially in litigation, the one thing I realized is it's like sports. It's not going to be always a perfect victory. It's not going to be perfect the very first time. There will be a lot of setbacks. What's important is you have to realize what is the long term goal for the client and for you in that case, and then try to achieve that in the best way possible. In that process, you may lose some small battles, but the idea is to win the war, not every single individual battle. So that's how I enjoy doing that.
Sir, I really like the way you phrased it, that it's like a game of chess, and then the analogies of losing a few battles for the final war. I guess that sort of a holistic approach and the constant introspection, constant reading and research has been the mantra. And I'm pretty sure with people who are really suffering from such a small attention span, with a dying reading practice, these words will definitely encourage and highlight how important is reading in this profession. You have been involved in a lot of high profile cases that have received media attention. And we all know how media attention can turn both ways. It can celebrate you one day, it can suddenly criticize you unnecessarily the other day. How do you keep calm in these specific high profile matters where really high stakes are involved?
I think I've been a little lucky because I've not really had to face that media pressure too much directly. But yes, in some cases, there were some difficult questions being put. I was getting calls from media houses for comments on a very contentious case where we were very strictly told by the client not to make any comments. See, even otherwise, generally in cases, I always try to just focus on the case itself and sort of blank out all the white noise, or as I call it, whatever is happening outside. And I think with high profile cases, it's even more important to realize that your role is limited to being a lawyer in that case and not bother about the repercussions, the consequences. Your job is limited to giving the best strategy, or whatever it is, the defense, or if you're prosecuting, the best advice to your client. The outcome is not in your hands, and equally what people make of it and what people think about it is not in your hands, and you have to just leave it at that. So if I had to put it in one word, you have to grow a little bit of a thick skin and ignore what the media is saying.
Thank you so much, sir, on focusing on these issues where we have to stay unidirectional, we have to stay focused and dedicated to our cause, even though others may not always be on the same page with it and others are entitled to their comments, but we have to stick to our cause. Moving ahead with the next question. Sir, your academic excellence in King's College is really praiseworthy. So, sir, being someone who has received schooling both domestically as well as abroad, how was law school life different there than that in India?
I think I should caveat this at the beginning by saying that my law school experience was 10 years ago. So I'm sure things have changed in India since then. But I think back then, for me, my experience was that in India, law schooling was still more focused on rote learning and not so much application based. Whereas when I went there, that was the one big difference that I saw. Even the way classes were conducted there. Typically in India, what happens is for covering a certain chapter on a certain day, when you come to class is when you open the book and then you understand the concept and everything. There, how it was structured was you were given a set of reading material before the class itself, and you were expected to read on your own. And of course, that may also have to do with the fact that it was a master's course. So I think there was already assumption that most of the people were already had a basic understanding of the law. But still, I think I really like that system. So you do your reading at home. And then when you come to class, what you're doing is actually taking the discussion to the next level. You're applying the knowledge that you've already read to difficult questions, or let's say there are some very, very specific controversial topics or difficult topics. You discuss that in more detail. And even the exams, the way the questions were structured, it was mostly problem-based questions. So you were not just required to reproduce whatever you learned. You had to apply what you've learned and try and give a solution. So I think that was a very big difference that I saw. And I think the second big difference that I saw was the encouragement that the faculty there gave to students to have, firstly, to form an opinion. Firstly, they would ask everybody, you should have an opinion on this. And second, the encouragement to say that, look, there is no right or wrong answer. Everybody is entitled to their own opinion. Of course, as long as you're able to back it up with a solid logic, they will, of course, attack the logic. If they don't disagree, they will question you on it. But if you're able to defend yourself, they appreciate. They say, okay, I have a certain point of view, you have a certain point of view. And as long as both are reasonable, that's that, right? So I think that openness and that application-based learning was something I really enjoyed in King's College.
That was very interesting. I'm sure law schools today in India are also trying to brace this particular change, and change is coming in, but we still need to imbibe this particular application-based thing a lot. So, sir, how did it shape your legal perceptions once you were back and engaged in practice in the country?
To be very honest, I would say it was partly that education, but also then working with some lawyers here who were educated there, and the way they looked at law actually changed my entire perspective of law. Generally, in most subjects in India, let me take, for example, I won't take law, but I'll take, medicine, right? You're considered a good doctor if you are able to just rattle off what is the right medicine for the right treatment, right? That's what you think is a good doctor. Similarly, with lawyers, the expectation in India is you should know every section. If I come to you with a legal problem, you should know the answer right then and there, and with section numbers and everything. And I realized that that's actually not what practicing law is about and being a good lawyer is about, because it's impractical for a lawyer, especially because our range of knowledge is so vast, to know every single law at the back of their hand. I think what is important, and that's what changed my perspective of practicing law, is how you read a law. That's what is important. So you're given a problem and then you relate that, okay, it relates to a particular subject. You pick up that law. Perhaps you've never read that law in your life before, but you should be able to read the bare act and immediately apply yourself and form and say, okay, this definition, there are certain things we can argue. This section, there are certain things you can argue. So the focus is not to just retain knowledge, but the focus is actually to learn how to use that knowledge or how to analyze knowledge. So I think in that sense, it really changed the way I looked at law and practicing law. I don't stress anymore about remembering things. I stress more about, okay, all the knowledge is in front of me. How do we strategize and how do we apply ourselves to that?
This definitely stands out, so that it's not the section which I can recall and tell, but how to read the law. How to read the law is such an application-based concept which we should all imbibe. No matter whether or not our colleges and our educational setups are telling that, we can definitely make it a practice. Thank you so much, sir. Talking on these lines, sir, how do you balance this personal life with professional commitments? Any hobbies or any passion, interests which keeps you lively?
So, as I said, I think a bit of going back to what we were talking about, the discipline point. So, going back a little on that, I think maintaining those points itself helps me balance out professional and personal life. And I'll come to the hobbies. But the other thing, it just came to my mind actually, that when you're at work and you get a call from home, you may answer sometimes, but usually, even if you answer the call, you say, I'll call you back. I'm at work, right? And I think the key is to give that same level of importance when you're at home spending time with your family or you're doing something personal. There will be emergencies sometimes. There are sometimes genuine emergencies where you have to take the call, you have to work. And I completely understand that. But more often than not, somebody calls you, even if it's from work or if it's a client, you can tell them, I'll call you back in some time. And I think you have to give that same respect to the time that you have at home as you do. So, the same thing, if somebody calls you while you're spending time with your family, if somebody from work calls you, equally tell them, I'll call you back in some time. That's something I try to follow. And in terms of hobbies, I've always been a sports fan. Like cricket is my passion and I love test cricket. So if I'm not working, usually I'm either following cricket, trying to play wherever I can. and just discussing cricket with with everybody that I know. So, and one of the things that I really love about sport is I feel that it's, and for me as a lawyer also, what we do in court, as I said, right, it's a game of chess, and it's very similar. In sports, you constantly see strategies and counter strategies, and that's something I really find very appealing. So I try to follow sports wherever I can, of course, play it as much as possible.
I was sort of guessing that sports would be your hobby because the way you put out the analogy in the beginning of the interview. Moving ahead, sir, corporate work culture in law firms versus litigation culture in chamber. If I would just put these two in front of you as two options, which one would you find better from your experience? And if you could just elaborate a bit.
Sure. I think both have their pros and cons. So me, of course, I'll explain. For my own personal reasons, I found litigation chamber work more appealing. But I think if you take the pros of both and try to combine them, which I see happening, and especially with our firm as well, and I'll explain how, I think that would be the ideal scenario. But with corporate work culture, I think one of the pros is that you are more directly in touch with the client, and that gives you a very different understanding. Because very often what I see is people who work only in litigation chambers, especially with corporate law and with commercial law. See, there is a position of law and then there is a commercial reality. And you have to understand that for a client, especially for a company or a business, for them, ultimately, the end goal is that commercial reality. Either they're trying to make money, they're trying to save money, or there is some goal that they have. Now, the legal position may not be helping that goal. So the idea is to try to find some way, some alternative or some middle path that actually satisfies that goal, but at the same time, obviously, is within the confines of the law. Because very often what I see is sometimes pure litigation chambers will either give you yes or no answers. This can be done, this cannot be done. Whereas when you're working in a corporate law firm, I think you develop that art of saying, okay, this strictly cannot be done, but we can explore this alternative. And I think that's very important. As a commercial lawyer, you have to be solution oriented. You just can't say this is allowed and this is not allowed. And I think the second advantage I see with law firms and with the corporate culture is you get more time on a particular case. Because in litigation chambers, it's literally the file comes to you the day before. So you don't have enough time to really actually read, get through, understand. Whereas in a law firm, you're probably working on that same case for 2, 3 months. So you've had enough time to interact with the client, get all the clarifications that you wanted, and really, that whole strategizing, they sort of build up that case. So I think that tends to be the advantage. So the cons, I would say, of law firm culture is one, sometimes, and this of course depends there. I'm not saying that all law firms are like this, but when you're working in a law firm, presenting something in a beautiful way, cosmetics is as important as the substance. But sometimes people tend to give more importance to the cosmetics than the substance itself, the form over substance. And that, to my mind, at least as a lawyer, a document may look very beautiful, but if in substance it's not good, then it should not be a document that passes the test. But sometimes there is a focus more on beautifying the document, etc. And I think the second con that I could personally, which I feel when you're in a law firm, is you don't get enough court time. You don't get to go to court every day, maybe once a week, in a month, 3, 4 times. So that's again a con. And with litigation chambers, I think, the converse. Basically, the pro is that the first focus is always the substance of the matter, because you don't really have the time to create beautiful. I mean, you're not really creating a document, but even if you have to, you're just focusing on what is the meat of the matter and the substance. I think there's a lot more stress on also points of law and developing points of law, finding judgments in support, interpreting a judgment. These are things you don't get time to do sometimes in a law firm because you're very busy getting the draft ready, etc. Whereas in a litigation chamber, for example, you get to read any judgment that you're relying on, also you're expected to read front to end and know that what is in our favor and what is against us also in a particular judgment. And of course, being in court every day is the advantage in a litigation law firm chamber. As I said, I think the con of then a litigation chamber is the opposite of a law firm, right? You don't get enough time to apply yourself to a file. So the sum and substance of all of this is what I think we're trying to do at Chandhiok and Mahajan, and particularly in the disputes team, is that we're trying to combine the best bits of both. So at Chandhiok and Mahajan, we are very, very, as a matter of principle, we don't recommend just briefing a senior counsel for every single matter. We are very happy to recommend to our clients that we will argue the matter. So that gives you that feel of being in a litigation chamber, because if you're arguing the matter, then you're going to prepare like an arguing counsel, everything. Equally, because we are a law firm, of course, we are interacting with the client and we're getting that. So I know that a lot of law firms just prefer to hand over the arguing bit to a senior counsel or an arguing counsel and say our job is done at the time of filing and then we're done. But we try to push as much as possible. Of course, it's the client's preference ultimately, but wherever possible, we try to do both. We try to argue our own cases as well, and that gives us the feeling of being in a litigation chamber as well. So, if you ask me, I think I know it's long-winded answer, but I would like to combine the best of both worlds. Would be my answer.
Thank you, sir. Talking about work and everything, sir, first of all, since you have been involved with dispute resolution and you so beautifully summarize the entire strategizing thing as a game of chess, how do you think that the new ADR mechanisms, for example, the mediation bill push, whatever, how do you see India's ADR structure in the coming years?
I think we've all realized that with arbitration, there were certain mistakes we made as a system. And because of that, it's not worked as well as people had hoped for. Mainly delays, court interference, things like that. And I think if we don't repeat those mistakes in this round, especially with mediation, I think that itself will go a long way. Because I think mediation, when it's done right, can be very, very effective. In fact, more effective than arbitration, I would say. And the reason is that mediation is essentially based on consent of the parties. In arbitration, you consent to the decision being taken by somebody outside the court, but in mediation, you are actually consenting on the substance. It's a settlement. And therefore, the scope for a court interfering is very, very little. And which is why I say, look, I think we've got a great opportunity now. And rightly so, I think the government is pushing mediation as one of the preferred forms of ADR. But we have to caution ourselves, learn from our mistakes. Number one, try to minimize court interference. And second, also, I think it does come down largely, and this is with all ADR, not just mediation. It comes down to the will of the parties. Because sometimes I think we have to admit to ourselves, especially as litigation lawyers, we often see ADR as just a method of delaying things. And especially with mediation. Everybody says yes to mediation, but they're never serious. The thing is, acha, theek hai, mediation mein chalega, 6 mahine aur kheench lenge. If that's the attitude we're going into mediation with, then it's not going to work. So at some level, maybe interference by courts would help because rather than, I think, because what we see right now is that courts, once it gets into mediation, very, very hands off. And sometimes extensions are given, of course, extensions are given when requested. But I think perhaps the court should also, rather than just asking for one report at the end, should keep taking interim reports on how the mediation is progressing. Because if the court feels that it's not working out, then I think better to pull out of the mediation rather than a prolonged, unnecessary mediation. So I hope it works. I genuinely hope it works. But I think, as I said, it comes down to these things. It comes down to tackling those challenges that we face, and it comes down to the will of the parties.
Understood. So you have highlighted on several aspects which are very important, and we should exercise caution in moving towards with the mediation bill and act, as you have mentioned, and not repeat the same mistakes and hope to see a better ADR structure. Sir, this question would be from all young lawyers and aspirants to someone who has believed in strategizing a lot and who has emphasized on strategizing, that what would be your advice to young law aspirants and people who want to choose law, people who are struggling in the initial phase of law, when they often have a lack of strategy?
I would say, look, you have to keep it simple sometimes. People sometimes tend to project law as more complicated than it is. So the first thing I would say is don't worry, it's not rocket science. And honestly, I keep telling a lot of my colleagues here as well that people who actually do science and innovation, I think the kind of knowledge and skill set that they require is much, much more. Law is still ultimately, it's a social science, it's human related, right? And I think one of the things to really, really understand is that it's a lot about psychological sort of understanding, especially as a litigation lawyer. Of course, you have to know the substance of your matter, but I think what's equally important is to understand who you're talking to, where that person is coming from, not just a judge, even as a corporate lawyer, for example. Dealing with a client, like this is something that we do sessions and session on. And I think one of the most important things we forget is that the client is ultimately a human being. And so he has certain considerations. So understanding what he or she, the client, wants, what pressures they are under, I think automatically makes things a lot easier. The only other thing I would say is that what I have noticed is that young lawyers nowadays are, and which is, I think, a very, very good thing, is that they are a lot more aware about their rights. Automatically, they demand work-life balance, and they realize that that is something that is a matter of right rather than something that they can expect once in a while. And they're a lot more comfortable with technology, which automatically makes them very, very efficient. I think the only piece of advice, if I may, that I would have for them is that sometimes you have to go back to being old school. And this goes back to what I was saying about detail. Sometimes using technology, you tend to miss out on details, and those details are very, very important. So yes, of course, use technology to your benefit. Nobody's saying no, but I think sometimes you have to go back and still do a manual double check. And you can't miss out on reading documents. Every single piece of information you should have read. You can't just leave it at the mercy of technology or just do smart selecting and filtering. Sometimes it's good to go back and be old fashioned, sometimes, is what I would say. In terms of if people are facing confusion, I think the one thing that I've noticed is that there are a lot more opportunities in law now. So don't be afraid of shifting, trying out different things, because I think in our profession, just coming out of law school, you can't be clear on what you want. It's impossible because you don't get that kind of exposure. Yes, you might have done internships, but that doesn't give you the same flavor of working. So try out different things. There's always time. Don't think that you're losing out on time. Try everything. In fact, try corporate, try litigation, try clerking, try media reporting, everything. And that's the only way you'll realize. Just don't think that it's too late to do anything. There's a lot of time. And then you can settle into whatever you're most comfortable with.
Sir, the way you have elaborated, and specifically on this point that just coming out of law school would not always give you that decision-making skill that I want to do something. This seems like a relief. This really seems like a relief to all of us youngsters who are planning to build a career and often feel confused. And we also appreciate the way you have always emphasized planning, the way you have emphasized on having the best of both the worlds at your firm. So, sir, what are your long-term plans? As in your personal trajectory in this profession, as well as how do you plan to take ahead your firm as well?
So I was working in Delhi till 2 years back. I've actually practiced most of my career. It's been at Delhi. Of course, for professional and personal reasons, I saw this as a very unique proposition to come and set up an office in Hyderabad. One, because I feel Hyderabad is a city that has a lot of potential that is still untapped. But equally, I think the proposition that we are trying to build here is very unique, which is that we want to run an entire South India disputes practice out of Hyderabad. We faced a lot of challenges initially, especially when virtual hearings were not very common because traveling is quite a problem. But thanks to the initiatives taken by the current Chief Justice of India, so at least high courts, they're all hybrid. So that really helps us manage matters. Of course, with district courts, etc., we'll have to rely on local councils once in a while. But it's a very unique proposition. I'm enjoying the role that we're trying to build. And so, really, I think the immediate goal for me is to continue to build this practice here into what we had envisioned, a proper South India disputes practice. And the long term goal is, of course, to continue in litigation with a niche in competition law. I think I never want to leave competition law. That's a specialization that I consciously chose right at the beginning of my career. But yes, I think eventually I do see myself hopefully arguing more matters in court and just continuing to do interesting work.
Your insights have been amazing today. Once again, thank you so much from the entire team of LawSikho Super Lawyers. We are sure that with the wealth of experience, practical experience, and tips which you have given us today, we have benefited. All the young ones will benefit, and whoever joins us for this session in quest for knowledge, in quest for some information and guidance, they will also be thoroughly benefited. So, thank you. Thank you so much.
Thank you. Thank you.